Do you have constitutional questions? Get constitutional answers. We'll be answering your constitutional questions live, so get ready to call in now. Are you a prosecutor, law enforcement officer, or local government employee? Want to make sure you are executing the laws in a constitutional manner? Are you a city council member, township board member, or state legislator? Want to ensure the laws you pass are constitutional? Perhaps you're a citizen who wants to know the proper limits on government and the protections for your God-given liberties. Regardless of your role, call me, Constitutional Attorney Catherine Henry, with your constitutional questions during our live call-in show now at the phone number listed on the screen. And remember, together we can restore freedom.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Hello, everyone. As we get started, I'm just going to make sure you guys can see me and hear me and everything's good, since we often have such technical difficulties. But from what I'm seeing, everything appears to be running okay. So unless I see something else in the comments, I'll go ahead and get rolling. So with that being said, hello and welcome. I'm Constitutional Attorney Catherine Henry, and this is Restore Freedom Weekly. And this is the time that you get to call in with your legal and constitutional questions, things about the proper role of government, what you should do if you are already in government. Maybe you're a mayor or serve on a zoning board, or maybe you're running for state rep. We've had candidates for governor, candidates for sheriff, candidates for Congress, candidates for the chair of the state Republican Party, all kinds of things on our show throughout the years. And so it doesn't matter if it's an office large or small. If you have any questions about what you should be doing or what would be constitutional in a certain scenario, this is what this show is all about. So please make sure to call in today and ask those questions. I want to say hello to everyone who I'm starting to see in the chat. And let's see here. All right. It looks like everything is good. And Mr. Henry, since you are watching, I did send you a text that was kind of important right before the show. So if you could check it out, unrelated to the show, that would be great. All right, so hopefully Lori will be joining us soon, and what is his YouTube name? The Liberty Cause? I don't know what his name is anymore. I think he changed it. Anyway, you guys know who I'm talking about. Hopefully one or both of them will be joining us today. I appreciate the compliment, Big Bad John, especially since I didn't really do much for makeup today. I threw some tinted lip gloss on and called it a day. That's why I put glasses on, because I didn't feel like doing all the makeup and stuff. So I'm distracting you with my really cool teal lenses, or frames, I should say. But anyway, so I'm going to go ahead and throw in the number to give us a call. And let's double check that I have... Yep, I have our call-in app already up and ready to go. So if you have any of those constitutional or legal questions, please make sure to give us a call at 616-303-0093. Now, I do my best to scroll through the chat several times throughout the show and make sure I'm catching any questions that are in there for me. But it's not a perfect scenario to do it that way, and I may very well miss a question. One thing that does help with things is, and normally Lori throws it in there, but since I haven't seen her jump in yet, I'm going to throw this in the chat. And let's see here. There we go. Okay, so I threw an example of what you would put in the chat if you wanted to ask a question that way. So for example, Black Quiver, I think, said that they were at an oil change place. So if it's too loud to try to call, but they had a question, they might throw the question in the chat. And what you would do is type the word question in all caps. So I see that a little bit more clearly when I'm scrolling through. It catches my eye more frequently, and then I can focus on that. And then just put the rest of your question in normal case, because obviously anything written in all caps is a little bit harder to read overall. So I don't want the whole question in capital letters, just the word question at the beginning. All right, so until we have some questions and some more people joining us today, I do, oh, I have a first caller. Hello, this is Catherine. Who am I speaking with?
Hi, Catherine. This is J.C. Turbot.
Yes, hi. How are you?
I'm good. How are you?
Oh, I'm definitely hanging in there. So what is the latest update that you have for us, or do you have a new question?
Well, on the zoning board, no update yet, and I have a new question.
Okay.
When I got out of the military, I started to go to law school.
Cool.
And work on my bachelor's. But I got hurt at work, so I had to quit. But I've always kept up with everything. But there was a question my question is, when I'm reading the Supreme Court cases, the dissenting opinions of the judges, does that hold any weight in law?
So, generally speaking, there's three types of opinions that come out. There is the majority opinion, there is a concurring opinion, and there is a dissenting opinion. The concurring opinion agrees with the result that came out, but either thinks additional explanation is needed, or perhaps they think the result is correct, but the entire reason that the court gave for that is wrong, and so they're giving a different reason for getting to the same result. A dissenting opinion is where they completely disagree on the result of the case, the outcome of the case, and then they want to give their opinion as to why. So a concurring opinion and a dissenting opinion are really the same, hold the same weight, which is really not much at all.
Okay.
So the most weight you have in a case is when you have a majority opinion, and that is the opinion of the court. It's literally called the opinion of the court. Now, it gets a little bit complicated sometimes when you have a divided court that is completely divided, and they are only agreeing on the result, but you don't have a majority of people agreeing on the reasons why. That does happen. And I mean, it happens probably more frequently than you would think. And it makes it really complicated because it's called a plurality opinion. And then how do you really consider that the opinion of the court? There might end up not really being a true opinion of the court because it's not a majority of the justices on the court. But in most cases, you have just a the majority agrees on not only a decision, but the reasons why, and they sign on to the opinion of the court, and that's the official law of the land in terms of how the Supreme Court is interpreting a situation. And then you have, like I said, the concurring and the dissenting opinions that don't really have a whole lot of weight, but those decisions oftentimes will be cited later on in other cases. Maybe the court changes its mind and they, like the oh my goodness, I'm losing the name of the case. Is it Dodd? No, that is not right. Anyway, whatever case just overturned Roe v. Wade a year or two ago. That case, I don't remember off the top of my head, but it is likely that they were citing dissenting opinions from the Roe v. Wade case, along with other opinions that have occurred since then. And so it's not so much that that dissenting opinion had any weight to it in Roe v. Wade. It didn't have weight until it was later basically adopted by a majority court opinion later on. Does that make sense?
Yes. Yes.
Okay. So did you have any follow-up questions about that thing, or did that kind of solve the issue that you were having with that?
Well, that solves the issue. Thank you. Because I'm reading this and I thought that the dissenting opinions that I've read did been brought up in other cases.
Yes.
With the judges when they had a similar case that they were working on.
Yes.
That came up. So I just thank you for clarifying that I was looking at this right.
Yeah, and let me clarify too a little bit further that just because, let's say, for example, there is a relatively new case. It was decided May 9th of last year. Cully versus Marshall, the Attorney General of Alabama. But this is a U.S. Supreme Court case, and I'm reading it because I'm getting ready to write another petition for writ of cert, this time to the U.S. Supreme Court. Working on that starting today. But anyway, as I'm looking through this, what I decided to do, I can't read cases like this on a computer. I can't do it. That's too much. These are not, short cases. So I printed the opinion of the court, which, just for those of you who might be able to see this on the screen, let's see if this works. It says right here, the opinion of the court, and then you'll see that that's the official opinion of the court. There was a majority of justices that agreed on the outcome of that. This particular decision also had one concurrence and one dissenting opinion. Sometimes you have multiple concurrences or multiple dissenting opinions, but this one had one concurrence. And so on a concurring opinion, sorry guys, I'm doing this like all backwards here. You'll see this is a concurring opinion, so it'll say the name of the justice, as I'm moving it in all the wrong directions. You'll see the name of the justice that authored it, and then it'll say concurring. So that is showing you this is a concurring opinion. And then it would do the same thing, but say, comma, dissenting opinion. I think Jackson might have been the one that wrote a dissenting opinion in this case. But I didn't print the dissenting opinion because, quite frankly, I don't care. It's a new enough opinion that the court dynamics haven't changed. The political landscape hasn't changed since 2024. So to me, there's no benefit in reading the dissenting opinion. The concurring opinion might bring out some things. I briefly glossed over it, and it seems like he's really hammering on some individual freedoms a little bit better or maybe stronger than what the main opinion does. So if I go to cite to that in my brief, it's not a controlling decision. It's basically like persuasive authority. It's persuasive. It's not controlling. But later on, that concurring opinion might very well be cited. And regardless of if it's a concurring opinion or a dissenting opinion, if that is cited in a later court opinion in the majority, whatever portion of that's being cited, and you have to be careful of how things are worded, because sometimes they'll cite to something in a dissenting opinion, and they'll say, at times, justices or courts have said this, and then they'll make a, fill in a quotation there, and then they'll say, but that really is illogical, and that's not how the law works, or whatever, so they're not, just because they're quoting it doesn't necessarily mean they're adopting it. But if they're quoting it to adopt it, if they're saying, well, in our, it's just common sense that we would, use, the whatever, and then they quote the prior dissenting opinion, for example. It's only the part that they're quoting. I mean, they will expressly state what they are adopting from that opinion. So it might be a half of a sentence that they are adopting as good law, so to speak. But that doesn't mean the whole rest of the opinion is now adopted as this good law. It's just that part that they have quoted and specifically adopted. And that's regardless of if it's a concurring opinion or a dissenting opinion. Something else to keep in mind with a concurring opinion or dissenting opinion is that in virtually every case that you have one of those types of opinions, the justices are going to be citing to various case precedent. And so sometimes they're citing to other non-binding authority, just persuasive, like another concurring opinion or another dissenting opinion. But oftentimes they will be citing to actual majority opinions of the court from a prior case. And so, they might have legitimate points. It's just what they are saying about it. Their own take on that case is just not being adopted as a full opinion of the court. But it might lead you to, I'm going to be reading this concurring opinion because this justice in this concurring opinion might very well be pointing me to prior precedent of another case that I hadn't found before that's going to support my position as well. So I know that's a lot of information I just gave you, but hopefully it all makes sense. So
Yeah, it makes sense. And what do you mean by good law?
I don't remember exactly how I said that, but yeah, I don't remember the context of what I was saying, but essentially it's if they're quoting a part of, like, say a majority opinion from 2024 is quoting a dissenting opinion from 2008. It's only the part that they are quoting. It's only the part that they are specifically adopting that now comes into the ranks of being considered case precedent. Okay, so if
Okay.
Usually I'm really good at analogies, but I am so overwhelmed right now with my own case that my brain is not functioning only like at 30% capacity. But let's say, okay, you guys know about my daughter, right? So this is like a really simplistic example and it has nothing to do with the law. But let's say the dissenting opinion was saying Catherine's daughter, her first name is Emma, and she's age 11, and she was wearing purple on Christmas Day. Okay. Let's say that's the dissenting opinion. That was an older case. The new case quotes part of what they said. They quote that my daughter's name is Emma. And they say, yep, we're accepting as good law. It's a silly example, I realize it's nothing to do with the law, but the good law is that, yep, we agree as a majority of the court, this new opinion of the court is acknowledging that it's good law that Catherine's daughter, her name is Emma. But they don't mention or they don't adopt anything about her age or the fact that she was wearing purple on Christmas Day. Then those pieces of that opinion are still just a dissenting opinion that don't matter. So they're not being adopted as part of this new case precedent. So it's really only it only becomes precedent, or what they call case law, when it's a majority opinion of the court. So you just got to look at the text of that majority opinion, and it might very well take pieces and parts from dissenting or concurring opinions, but it's only those parts that are taken into that majority opinion that are part of the new case precedent. Did that kind of clear it up as to what good law was really meant?
Yes.
Okay.
Yes, I understand.
Okay,
Yes.
cool. Did you have any?
Okay, thank you very much.
You're welcome.
I appreciate it.
Yes, have a great day.
You too.
Thank you. Okay, so I think I saw that there might have been questions. Oh, and I didn't even switch our caller on the line screen there, so sorry about that, guys. But you guys figured it out. You could hear that we had a caller on the line. Okay, I'm scrolling back and I see, oh, that was my own example. See, it caught my eye. That's my own example, so follow that example. Okay. Question: how would one find case law on terminating parental rights? First of all, I just want to be clear. The courts and attorneys everywhere call it case law. And you guys can't see it, but I have these little blonde hairs that are continually attacking my own face and driving me nuts. So I look like I'm losing my mind because it's kind of like oh, you could see some of them. They're floating around right there, but they're like going like this and they're getting me in the face. And so I'm not losing my mind. I mean, I already lost it, but I'm not losing it anymore. But actually, I am going to step away from this just for a second. It's hard to imagine having an August in Florida where I'm not going to have my fan on and my AC blowing on me. I can't turn the AC down because I still have it at like 82 in here. But at least that fan, maybe turning that off completely might help. Anyway, so I just want to be clear that even though they call it case law, it's case precedent. Law is set by legislatures. It's set by city councils, county commissions, county councils if you're in the stupid state of Florida that doesn't know how to get that correct. Anyway, you know what I mean. It's your legislative body. Laws are made by legislative bodies. So with that in mind, to answer your question, where do you find case precedent on terminating parental rights? There's some that you're going to see in the U.S. Supreme Court. There's some you're going to see, and I don't remember, John, if you have told me before, I'm sorry, I'm mixing up people, but if you're from Michigan or not. But assuming for the moment that you're from Michigan, you would look to your Michigan Supreme Court cases about that, as well as Court of Appeals decisions that have not been overruled. One place that I've done a little video on this before. Let me see. Shoot. Is there a way? Wish there was an easy way for me to share my screen in here. I probably have it set up and I just don't see it. So, I am not seeing it. Video file. Nope, those are old video files. Okay, that sucks. Well, anyway. Okay, so what I wanted to do is show you Google Scholar, and I use them fairly frequently, actually, and I'm going to open the Google Scholar app while we're talking so I can kind of walk you through some of that. And I'm just writing a note to myself as well about what we're talking about. Okay, so, all right, when you go to Google Scholar, I actually have the app downloaded to my computer, as well as you could just go to, I think it's scholar.google.com, and it'll give you a search bar that looks like any other Google search bar, but it defaults to articles. I don't give a crap about articles. So don't ever look for that. Always make sure, and there's no way to change this default, unfortunately, but always click the case law. Yeah, it says case law, not case precedent, but anyway, you go from there and you can type in, I think you were asking about termination of parental rights. And so I click termination of parental rights and I hit enter. Now, on the screen that you were first on, you can actually limit what jurisdictions you want to have in your search results. Or once you have that, once maybe initially you don't really care, you're looking for anything in the country just to kind of get you rolling on things. But man, I just typed in termination of parental rights and I have about 113,000 results. So I should probably narrow that down. You'll see on the top right that you can narrow that down by year. And you can also select which courts. So you can, if you go to the right-hand side, there's a drop-down case law with a little arrow. And if you click that arrow, it gives you an option just to select federal courts, just to select, for me, Florida courts, because I have previously selected that before, or just to the select courts. And then it has all of them checked initially, and then you can go and unselect all of them and only pick the ones you want. So if let's say, I don't remember, like I said, what state you're in, but I'm going to clear all, and I'm going to go to federal courts and click Supreme Court, which is the very top one listed. That is the U.S. Supreme Court. And then I'm also going to go in the state court column and click for Michigan, I'm going to click Court of Appeals and Supreme Court. Actually, I know there's enough court decisions in the Supreme Court that I'm not going to click the Court of Appeals because they're still going to get way too many. But there could be some binding case precedent that is coming out of your Court of Appeals if the Supreme Court did not decide the case, or maybe they just affirmed a lower court decision or whatever. So anyway, for this example, I've selected the Michigan Supreme Court and the U.S. Supreme Court. I'm going to hit done, and then it's going to refine my results. I'm still getting 2,230 hits in Google Scholar here. The very first one it gives me is Santosky versus Kramer, a U.S. Supreme Court case from 1982. Wow, that predates me. Now, the frustrating thing about this is it doesn't exactly... It's not as easy to see if I had, and I haven't used Westlaw or LexisNexis in many years because I can't afford it as a pro bono attorney. But when you first get those case results, there's ways that you can narrow down to only good results. Otherwise, it'll still show the cases that have been overruled, but without even clicking on it, it usually gives some sort of indication at the bottom that that case has been overruled. And then you can just go, you know what, I'm not even going to touch that case. And then you can just skip. Now, the danger of skipping a case that's been overruled is it's not necessarily true that the entire case has been overruled. Sometimes it's just a small portion of a case that's been overruled and the rest of it remains good case law, in quotation marks there. So it is still a good idea to even look at things that have been overruled or overturned. And really, it's a rabbit hole, because then if you're using a service like LexisNexis or Westlaw, you can easily click and go, oh, okay, well, which cases have, given this negative treatment is what they typically call it. And so then you click on that, and sometimes there's a whole laundry list of cases that have given it negative treatment. And then you want to click on each one of those and read to see exactly what they have said about your case that you found, to see what kind of negative treatment. And sometimes the service like Westlaw gets it wrong, and it's not exactly negative. It's just mentioned, basically. But sometimes it is. Oftentimes they do get it right, and it's been overturned in some way or something like that. So anyway, it gets a little bit complicated, but it's a lot of rabbit holes. And so it's best that you sometimes just print all of your search results and then just start following that whole, all those rabbit hole trails, and then just kind of check some boxes as you continue to go, and then you can remember where you started off and where you would initially have to come back to. So at any rate, that is what I would do if I was looking for termination of parental rights cases. I could tell you, for example, in Michigan, there's been several just this year alone that have made it to the Court of Appeals and Michigan Supreme Court that I've read that talk about various different aspects of termination of parental rights. Let's see what one. So if I narrow it down by year and I say, I just want to know this year alone, what cases have come out on termination of parental rights, it tells me that in the Michigan Supreme Court or the U.S. Supreme Court, only those two courts, 9 cases have been decided that discuss termination of parental rights. So that's a lot less to deal with, right? And a lot less to try to read and figure out. So anyway, that is really, and because it's a free service, it's one of the best that you can use. I mean, you're putting all the power of Google and searching and, how you can use connectors and all that other stuff, search language, right, to get what you want and narrow down by court and things like that in a way that truly is easier than a lot of these other search engines for court cases. But anyway. Okay, so, Liberty Warrior, that's what his name is. You guys heard me trying to figure that out at the beginning of the show. I was like, he changed it again. I don't remember, but it's Liberty Warrior, guys. So welcome our friend Liberty Warrior. Let's see here. So I got to get back to where your question was. And okay. So, it just did that jumping thing on me again. I had just gotten to the very next question and okay. Liberty Warrior, just this happened to catch my eye. It's not a question, but I see that there's a statement. We are seeing and have seen a usurpation of power by the courts for over a century. Yeah, that's for damn sure. The courts are taking more power than what is rightfully bestowed upon them by the people. And also, at the same time, they are neglecting to exercise jurisdiction on thousands, if not millions of cases where justice requires them to act. Typically, where government, I think I have a storm outside, either that or somebody's banging on my door, not sure. Typically, where government has done something to infringe upon the rights of an individual and they are, they take it to court, they're trying to do the right thing, like us, we brought it to circuit court, we brought it to the Court of Appeals, and every court we are in front of, every judge that has looked at it has not answered the vast majority of the legal questions we've placed in front of them. Basically, the assertions we've made when we've said our rights to equal protection have been violated. How about the fact that the city cannot force us to do something that would literally put us in non-compliance of the city's ordinances, the city code? They can't do that. We brought that up and the circuit court was like, I don't see anything. I don't hear anything. What are you talking about? And they didn't address it. And then the Court of Appeals, we brought that up among many other things. And lo and behold, what did the Court of Appeals do? The Court of Appeals said, we're just going to dismiss your case because this sounds like it's too much work for us. They just dismissed it. And so I filed a motion for reconsideration. Rehearing is what it's called at the Court of Appeals level here in Florida, but it's a motion for reconsideration because there was no hearing. And I also filed, in the alternative, I filed a motion to get a written opinion so that if they were going to deny me again on the merits of my case, then I could at least bring it to the Florida Supreme Court. Because the way the court rules and the Constitution down here is written, it's a big mess, it's stupid, it's ugly, it's awful, and it denies people access to the Florida Supreme Court because they claim they don't have enough judicial resources. Well, if there's not enough judicial resources, maybe it's because the governments are violating people's rights too much left and right, and they should be stopped so not so many cases have to be filed. I don't know. Maybe we should actually fix the problems. But at any rate, the Court of Appeals said, nah, we're not going to give you a written opinion and tell you why we're not taking your case. We're just not going to take it. So then that literally stops me. I have no ability whatsoever. It takes jurisdiction totally away from the Florida Supreme Court. If I went to the Florida Supreme Court today and said, please take my case, they would say, sorry, can't. And it sucks. So my only shot right now is going to the U.S. Supreme Court and saying, now I know that normally you look at cases, it's written into the court rules about what the considerations are in a petition for writ of certiorari, the kinds of things they look at. And I'm going to have to look at it more carefully today and figure out if there's a way to squeeze in there that we need this intervention. But where court after court after court just doesn't address legal issues, and it thereby allows a government entity to just trample all over our rights. They're trying to take our frickin' house and our cars and everything we own. Seriously, that is, how much worse could it get? In a civil case, it can't get any worse. In a criminal case, yeah, I guess there could be, jail and other physical penalties onto us. But in a civil case, that's as worse as it gets, right? Literally wiping us out and taking everything we own and continue to own for all eternity. I mean, that's what they're trying to do. So I have to figure out a way to convince the U.S. Supreme Court to take our case, even though what they normally do is they only take cases when they see that lower courts have made a full decision. The issues have been fully briefed in cases below, in the courts below, and the courts have given it due consideration, and that the Court of Appeal, the U.S. Supreme Court is the court of last resort, and they're not supposed to be the court where these issues are first addressed. Okay? So with that being said, they often then make sure they'll jump in if a lower court has just purely gotten it wrong. But more frequently, they jump in if two lower courts are conflicting, like a court of appeals from the Ninth Circuit and the Fifth Circuit have a different result on the same issue. That's more likely where the U.S. Supreme Court's going to jump in and say, okay, yep, we need to handle this. We need to tell the whole country what's really up here. And I'm nowhere near that because I've been denied the right to have these issues decided by courts. And it's not my wrongdoing. I have fully briefed the issues. So anyway, what he says is true, that we are seeing a usurpation of power by the courts, but also a dereliction of duty, which I would say is even more grotesque than the usurpation of power. Okay, so Six Oaks Farm pointed out or states, case law is simply a court's interpretation of legislative law statutes. That's the way it's kind of, you're led to believe, but actually no, because what Liberty Warrior pointed out with the usurpation of courts, they will oftentimes fill in all kinds of blanks and come up with stuff that was not ever put in statute. So it's not just interpreting a statute. They literally at times will go, well, there's no statute on the books, or even worse yet, there's a statute that says 1, 2, 3, but we're going to say, nope, the law really should be X, Y, Z. And so then you have this whole new law that's in the books, in this case precedent. So it's beyond what just we think of as it just being statutory interpretation. And case law, Big Bad John says, case law should not be considered as a permanent thing. Right. Because actually what courts are only supposed to do is decide or resolve disputes between specific parties. And really the the U.S. Supreme Court basically said that in one of their recent opinions. I want to say it was June. I want to say the end of June of this year. I forgot what case it is, but it was one of the cases, I think that came to it in the context of there were several cases. A Democrat was suing the Trump administration. Let's put it that way. I don't remember if it was in the context of the illegal immigrants being deported, or if it was in the context of doing the mass layoffs through the Department of Government Efficiency, or, you know, reducing the grants and spending and things like that the government has been trying to cut back on since Trump got into office. It was one of those, okay? Because there's been, if you guys are not aware, there's been dozens of cases like that, and several of them have already made their way up all the way to the U.S. Supreme Court. So one of those cases challenging the Trump administration's activities very recently, what the Supreme Court did is they didn't really acknowledge the merits of the case below. And we'll just say it was the illegal immigrant deportation case. I don't know for sure, but for easy example, what they said is that nationwide injunctions by federal courts most likely, they didn't even come out and just say they flat out do. They just said they most likely step outside of the bounds of what their authority is given to them in the Constitution. So they said to lower courts, no, nationwide injunctions, that's not what you should be doing. And of course, there was one of the federal judges on the an illegal immigrants case who then turned around and like days later said, I don't care, and then did a nationwide injunction anyway. So yeah, it's great. That's usurpation of power at its finest. But anyway, so they should not be considered a permanent thing. All right, so I'm trying to scroll here and see. Yes, John Q. Public, you didn't get a notification. It might be the fact that yesterday we were driving all the way to far reaches of Jacksonville, picked up our older daughter, had her with us and Emma for a few hours, and then both Emma and her older sister got back on a plane and flew to Michigan yesterday, and then we had to make our way back down here. And then Emma's homeschool co-op had an orientation night, so then we were there for 2 hours. And by the time we got home, we didn't eat dinner till like 9:30, 10 o'clock at night. So anyway, I did not get the stream set up yesterday like I was hoping. And so I had to set it up this morning, and that probably affected whether you were getting, I set it up, I think at like 8:30 or something like that this morning, but it's still probably, I think it was 8 o'clock. But anyway, and hello back to Warren, Michigan. All right, so shoot, it just scrolled again. I know there was another question. Oh, there's two. Oh, there's lots of them. Okay, I did not see where it jumped to. So, Jake Hurvitz says, did you watch the video with did I watch the video on Long Island audits that was discussed 2 weeks ago? So Lori was working, I have, as far as I know, she's still working on it. Last update I got from her is that she's still working on trying to like shorten it, that there's a bunch of really long videos out there, and I quite frankly just don't have the time to watch somebody else's really long videos. So what I was looking for is somebody to send me the shortened version of that video so that I can watch it and have my own informed opinion on that. But it sounded, I don't know if there were multiple different videos that each held a different aspect to the situation. I wasn't quite understanding when she said she still had to collect some more or put some more in there. So I was waiting till it was all done so I could watch it and, take it all in at the same time. So if anybody has it already in one place, because I know she was having some technical difficulties in being able to like record or pull or whatever all the terms are, parts of his videos. If somebody else already has the shortened version of what happened, like right to the guts of the situation, I'd love to have that. I can't remember. I want to say it was someone with at least an email address that shows up as individualist. Did send me some short videos before that Long Island audits thing happened. And it is one of those emails that I keep snoozing, and I'm like, I gotta get to it. I want to get to it in the next few days, and I haven't gotten to it. So those just short videos that somebody wanted a reaction on or some information about. And I still have that in my short to-do list. But these 2 weeks, other than this show, this episode right here, other than this, everything in the next 2 weeks is going to be me working on my petition for writ of certiorari in the U.S. Supreme Court, because I am extremely overwhelmed with all that entails. And e-filing is required if you're an attorney. It's not allowed if you're not an attorney, if you're self-represented, but I am a self-represented attorney who's admitted to practice in the U.S. Supreme Court. But even if you file electronically, it's not their normal ECF system. It sounds like it's a different ECF type of system. And even if you file electronically, you still have to file everything in paper. And filing in paper is not just printing it on a simple old 8.5 by 11 sheet of paper. Oh no, it's got to be on this weird, funky, smaller paper that is on 60-pound weight. It's like a normal piece of paper is 20-pound weight. It's got to be booklet bound. You have to have 40 copies of each booklet submitted, and that's for each document, like a motion or a petition. Each document is its own booklet. The whole thing is ridiculous, and it's set up as a system to basically make sure people can't participate. So and if you do it that way, you have to format it for this really short, small piece of paper. You have to then take the same exact document and format it for a normal 8.5 by 11 to be able to upload it electronically if you're considered an attorney on the case. And everything it's confusing and complicated. And anyway, so I'm trying to figure out if they're going to consider me an attorney or not consider me an attorney for purposes of this case, since I would be representing myself. So anyway, okay. Wouldn't dueling with pistols be a lot more efficient than going through the judicial process? You know, John Q. Public, yeah, it would be a lot more efficient. And if I could just be practicing at the gun range and then have my gun out and be dueling with these city officials, especially if their shooting is as good as their legal briefs are, I will win, no problem. I don't need any body armor. I don't need anything. If their shooting is even remotely as to the same level as their legal writing is, I've got this down cold. Unfortunately, that's not an option I was given, so... Okay. Shoot. I swear there were a few more. Oh, okay. Yep. Looks like there were a couple more questions. Okay. John Q. Public, have you reviewed the Federal Circuit Court of Appeals decision that got... I don't know what GVR is off the top of my head. That got GVR from the Supreme Court, U.S. v. Damian Wilson, that there is no crime against carrying a firearm. I don't remember. Did you email me that? I know somebody emailed me a recent case about something, and it didn't quite match up. But anyway, I don't know. The answer is I don't know, because I often don't remember cases of names. Kind of like I don't remember the names of songs. My Zumba instructor is always like, you know, what kind of song what songs do you want me to play? And everybody else comes up with names of songs, or at least artists. And I'm like, I don't know. And I'm like, what about the one where and then I show her what our feet look like in the dance moves. And she's like, oh, that's this one. Oh, that's, you know, whatever, right? See, I can't even give you an example because I don't know. Anyway, so I'll show her the dance, and it could be complicated. It could be like, you know, whatever. And I've got the whole thing. I know what song it goes with. I know what the beat is. I know what it sounds like, but I don't know the names of the songs or the artists. And so it's kind of funny because I'll say that to her every time. I'm like, Gina, you know I don't know the names of the songs. And she says, no, but you sure know the choreography to all of them. So that's the kind of thing with, I guess my brain just works that way. I know the hard parts of something and not necessarily the easy parts. So if I've read a case, then I know the ins and outs of it. I've read it. I've dissected it. I know what helps me in it in a particular situation. I know what doesn't help me. Whatever, right? But I, won't necessarily remember the name of the case unless it's right in front of me. So, let's see. Okay, why, we got another question from John here. Why is it that city attorneys are willing to sit back and allow unconstitutional ordinances to be passed and not advise on the constitutional issues? So this is a little bit complicated in that what I have learned over the years is that different jurisdictions actually might have two different sets of city attorneys, if that makes sense. And let me further explain. So hopefully it does. So sometimes they have a city attorney that you see and hear about. It's the city attorney that is doing the prosecutions, for example. It's the city attorney that is, if somebody is charged with an offense, they're in court and they're, bringing the case to trial and they're doing all the things on the courtroom side of things. Then you have sometimes corporate counsel or inside counsel, or they give it all kinds of names, advisory counsel. But you might have another attorney that's essentially not doing any trial work, but they're the ones that are giving advice on the back end, right? They're the ones giving advice on, okay, so what ordinances, what local laws should we put into place? What actions should we take in a given scenario? Are we allowed to do a tax foreclosure on this certain property, or whatever the case is? And so you have different, sometimes two different sets of city attorneys, depending on the jurisdiction. Now, I would say both of them should be responsible for making sure that there are only constitutional ordinances on the books. Now, I will say, if you have somebody who's a trial attorney for the city who's not involved in the passing of ordinances or like the back end work, they're only doing the trial work, then it might be reasonable to say in those situations, I would say it is reasonable to say in those situations, that the attorney's obligation in that regard would be to make sure that any of the laws that they are using to prosecute people, any of the laws that come up in the course of their work as a trial attorney, any of the city ordinances, city codes, that kind of thing, that come up in their work as a city attorney, they have the obligation to make sure that those are constitutional in nature. And if they happen to come across one that they're like, oh, this hasn't been charged before, and let me take a look at it, ooh, yeah, this does not seem like it's constitutional in nature, they need to do their due diligence. And if they determine it is not constitutional, they have an obligation to throw it out. But then I would say they need to take it a step further and do some sort of written, recommendation to the actual city council or whatever your governing body is there, a township board or whatever, that to say to them, listen, this on such and such date, this, a case came across my desk to prosecute someone for violation of Ordinance 1234. But after thorough review of Ordinance 1234, we have found it to be facially unconstitutional. And therefore, this whole ordinance must be rescinded. It must be taken off the books. You need to take immediate action as a governing body to remove it from the laws of the community. And so that's what I would say their role is. And if you have an attorney who is a city attorney doing the behind the scenes work, then I think absolutely it's their job to make sure that only constitutional laws are being passed and that they need a clean house. So someday, who knows, God may put me in the position of being the city attorney for the city of Ormond Beach. And if he does, you better believe I'm going to be going through all those ordinances, all the policies, all the procedures, every single thing top to bottom to figure out what is constitutional in nature. If it's not constitutional in nature, I don't care what the excuse is, what the reason is, or how many years it's been on the books, it's got to go. So we would be drastically reducing the number of things on the books because a large portion of them are unconstitutional. Even if they didn't start as unconstitutional, things just grow and get legs of their own, and then they just get massive. And so what may have started out as a great idea, like the concept of zoning, I think most people would agree the concept of zoning in the sense that, yeah, you don't want a strip club to be able to be built right next to an elementary school. You don't want a liquor store or a pot store to be built right next to a daycare or an elementary school, right? Or a high school. I mean, geez, those are the most impressionable kids. Let's keep that stuff away. Let's keep adult stuff for adults and kid stuff for kids. And, so you have stuff like that, the most common sense basic of things, right? But when it comes down to these days, zoning is like, well, you have zoning codes and there's, R1, R2, R3, R4, R15, and, R1 is single family residential, R2 is single and duplex, R3, whatever. And it gets super complex and confusing and overwhelming, and you have page after page after page, and then you add new things, and that's not okay. And so that's where things need to change. But man, you guys have continued the chat and it's great, but it just keeps making my thing scroll here. It doesn't let me just stick with what I was reading. So anyway, the question being, how are they allowed to sit back and allow unconstitutional ordinances to be passed and not advise on the constitutional issues? And they should. And quite frankly, I think that their seat should be vacated, should be considered as vacated if they're not doing that. It's dereliction of duty, but who's going to do that? That's the problem. It's the very people that are passing the unconstitutional ordinances that typically would have to declare that seat vacant for dereliction of duty or whatever, or at least be the people that file the official report that gives it to some other governing body that then has the authority to take action and declare the seat vacant and all that. And it's a mess. So Liberty Warrior says that here in Volusia County, Florida, which is where he and I both live, it is 100% about the money and the buddy system, taking care of the good old boy system. That's not just in Volusia County, though. That's everywhere. I mean, we have some callers, he's definitely someone who's called before, but he's someone who has asked questions before from northern Michigan, in the county that I was born in, very, very tiny, where they see this happening. Caller from 586, give me a call, just give me 10 seconds to finish this thought. But it doesn't matter if it's a very small, tiny town in the middle of nowhere that has 10,000 people and, the whole county, or if it's a big community like ours, it happens. Hello, this is someone who has called us before, and I feel like this is someone we've had issues with the phone not working, but 586 area code, go ahead and give me a call again. I don't remember exactly who you are. I just know that I've spoken with you. But give me a call again, and I tried to answer it this time. It just, I don't know. I don't know what's going on there. One more time. Hello, can you hear me?
Yes, Miss Henry, I'm sorry. I don't know why my phone does that. Every time I try to call you in, it does that hang up thing. So it's not being done on purpose. It's just, I think it's the phone.
Oh, I'm sure it's the evil technology warlord, underlords, or what do you want to call them, that just try to tank any efforts to make our country what it needs to be. But anyway.
Anyways, I'm John Q. Public in the chat. So
yes.
Everybody knows me. Okay. Anyways, I was going to go back to the Fifth Circuit Court of Appeals decision, which was Damian Wilson. And this just came out on the 17th of July, and the federal court decided that there is no constitutional gun crimes that are constitutional based on manner of carry, or if you have a permit or don't have a permit. And that case went to the Fifth Circuit, then it went to the en banc, and then the en banc sent it up to the Supreme Court. And then the Supreme Court said, listen, we've already ruled on this via the Bruin decision, get the decision right. So they did the grant, vacated, and reviewed the GVR back down to the Fifth Circuit, and they said, clean it up, make the decision right, and that's going to be the final ruling on this here. And they did that. But yet, we still have all these other states now that are still not following the GVR from the Supreme Court that was this decision in the Fifth Circuit Court of Appeals that said that there is no such thing as a gun crime as far as the Constitution is concerned, with the manner of carry, concealed or open carry, or whether a person has a permit or doesn't have a permit.
Now, because I haven't seen the order myself, in the order that you're talking about that came from the U.S. Supreme Court to grant, vacate, and then remand,
Or
did
remand.
did they is that in that order the U.S. Supreme Court specifically agreed that the Constitution does not allow there to be a crime for, carrying a firearm?
No, they simply told the Fifth Circuit Court of Appeal, the en banc, they told them, reread our decision in the Bruin decision, reread what the means test is, the scrutiny standard that we came up for the Second Amendment, and follow it to the T and adjust your ruling. That's what they said. And then the ruling was adjusted to where they made that ruling that there is no law on the book that could circumvent the Second Amendment right based on manner of carry or whether a person had a permit or didn't have a permit. It wasn't a crime.
And
there was a 36-page opinion that they wrote on this.
Have you seen if there's any action that tried to bring it back to the U.S. Supreme Court?
No, I have not, since it was authored on the 17th, and a lot of so-called gun tubers have covered this case of Damian Wilson. He also is involved with a lot of stuff having to do with the having the right to travel, license plates, insurance, and driver's license, that kind of thing. And this is a case that he was involved with a Second Amendment issue. So he's very well involved in Second Amendment and First Amendment issues and right to travel.
Okay. So, so I would say at this point, based on the limited information that I have, is that it's not fair to say that federal case precedent is out there that basically is blanket across the country that clearly says, reaffirms that we have a constitutional right to carry and we can't have a crime for carrying, just because we don't have a permit or those kinds of things. That if anything, it sounds like that would only be applicable in the Fifth Circuit. So it doesn't convey to other circuits until those circuits adopt it, or until the U.S. Supreme Court essentially adopts it or makes it clear that it applies everywhere. So just based on what's happened so far with the U.S. Supreme Court vacating what they had done so far to that point, and then telling them to clean it up and make it more consistent with the Bruin case, that doesn't mean that the court was adopting what their standard was or what their outcome was. So it could very well be that if it made it back to the U.S. Supreme Court, the U.S. Supreme Court might say, no, you guys are dumb. We disagree with you. This is not at all, whatever. Or it could be that they agree and maybe they would deny cert, saying this court has, now come to the right conclusion and everybody just needs to follow the precedent that was created there. But we don't, until we have something like that, other jurisdictions, other circuits in the Federal Court of Appeals breakdown, if you will, like down here, I'm in the 11th Circuit. Other circuits are essentially free to do whatever they want. It's only considered persuasive authority if you want to grab a case from another jurisdiction. So it's kind of, the analogy is saying a Fifth Circuit Court of Appeals case in the federal court system has about as much weight, say, in, like I said, I'm in the 11th Circuit, just about as much weight in the 11th Circuit Court of Appeals as me being now in the state of Florida. If I wanted to try to cite to a Michigan Supreme Court case down here in the state of Florida, they're going to say, that's really cute. We're glad that Michigan has decided that. But as long as there's other kinds of cases that are controlling here in the state of Florida, they're not going to look at what's happening in the state of Michigan. They're going to say that's irrelevant. It's non-binding precedent. It's not even, it's not even precedent. It's, it's from another jurisdiction. So anyway, it's not that it's not good news. If the case is saying everything that you're saying the final version is saying, that's still good news. but it's just not rising to the level of really being that true victory. You know, like the Bruin case didn't even remotely do what it should have, but the little bit of victory that it did give set the tone for the whole country because of the stance of the case, the procedural framework of the case, and being a decision in the U.S. Supreme Court. So I don't know if that kind of clarifies.
So I brought this all up to my court-appointed public defender. Basically, every time I see a new federal ruling on this, or even a state court ruling, I brought it to the attention of the attorney and said, look, that this is here. And I always thought, and maybe it's because I'm a constitutional absolutist, I always thought that the full faith and credit clause under Article 4 of our Constitution specifically said that whatever a law is in one state is supposed to be the law in another state. At least that was my understanding of the full faith and credit clause. So why would that not apply to judicial judgments that have created that a law was unconstitutional in one state, and therefore it would be unconstitutional in another state if they try to enforce it?
Because that's not what I can't even talk today. Full faith and credit, it's not even, does not sound right. Give me a second here. I'm trying to do two things in one. Yeah, okay. The full faith and credit clause, that's not what it means. So essentially the way you just described it would be like if Florida wanted to make a law that all roads in non-residential areas, the speed limit was 70 miles an hour. That does not mean that anybody driving from Florida up to Georgia, then Georgia has to accept that 70 miles an hour is the speed limit down here. And if they want to set their speed limit at 60, they can't give tickets to people that have just come from Florida roads. Do you know what I mean? That the way you described it, that's how that would play out. And that's not, each jurisdiction has the right to have their own procedures and rules, their own laws. They all have to be constitutional in nature, but that's beside the point. That's not the point of the full faith and credit clause. So anybody wondering, because this is not something that we talk about all the time, Article 4, Section 1 of the U.S. Constitution says, it's not a very long one. In fact, it's only one sentence long, a complicated sentence, but one sentence long. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. Now, so the biggest thing that I would say is the way that this plays out is that if you have someone who, let's say Mike and I got divorced in the state of Florida, and I wanted to move to the state of Georgia. And but there, for whatever reason, I, let's say I found, Joe Smith, and I wanted to marry Joe Smith. And they're like, well, wait a second. You can't get married to Joe Smith because you're married to Mike Henry. And I'd say, well, no, I'm not. I got divorced in Florida. They'd say, they can't say that to me they can't say, well, that's Florida. That's not here. You didn't get divorced up here. Full faith and credit means that they have to take that, whatever laws and procedures that governed that divorce in Florida, as long as, it was done validly down here according to the laws here, they have to accept that up there in Georgia. Similar with a criminal case. Let's say somebody from Georgia is convicted of some sort of, they're convicted of assault. And they come down here and they want to apply to work in a daycare. Then laws down here, if you want to work in, a daycare setting or with children or whatever, there's all kinds of laws on screenings and, that you have to pass certain background checks and things like that. And Florida, in those scenarios or those situations, If it says that you cannot work in a daycare facility if you have a violent record of some kind, if you have an assault conviction or whatever, they can't look at that and say, well, your assault conviction was from Georgia, so that doesn't apply here. So you're good. You could still work with kids. Or, better yet, you've been to 49 other states and you have assault, criminal sexual conduct, basically rape convictions, you have assault and battery convictions, you have, assault with intent to commit great bodily harm, all these, kinds of violent crimes towards others, but they were all in other states. So we don't recognize that. You can totally work here in the state of Florida, caring for 3-year-old children, because those convictions didn't happen down here. That's what it's talking about. Florida has to recognize that if there was a valid conviction that hasn't been overturned in another state, or a valid divorce, or a valid marriage, whatever the procedures are, those are just some of the easiest. Driver's license. If you have a valid driver's license in the state of Michigan and you're driving down on vacation, you come to Florida, they can't say, oh, well, you don't have a Florida driver's license. No, full faith and credit clause means they have to recognize that if you have a validly issued, non-expired Michigan driver's license, then they have to recognize that. Setting aside that I agree we shouldn't have to have driver's licenses in the first place, all that, I'm just giving you guys examples, but does that make sense?
Well, yeah, I guess so. So then that would validate then the judge's decision to not follow any of the federal judgments that have been made, or even the national constitution, because she's using a state case, the Langston case out of West Michigan. She's using that to circumvent the Second Amendment, our state constitution, or any of the federal judgments, including Bruin, to continue on with violating Second Amendment here in the state of Michigan.
Yeah, judges are always going to do stupid things, right? And sometimes they are relying on cases. Okay, so giving the judiciary the benefit of the doubt for the time being, let's say that there is, on your particular issue, and I know we've talked about it before, but I'm just keeping it simple for the point of this example. Let's say your particular issue, there's not really a clear U.S. Supreme Court case on it. Yes, it's Second Amendment, but let's just say there's something particular and unique about it. And so there's really only court cases from, state courts and maybe courts of appeals across the country, but nothing has made it to the U.S. Supreme Court that's supposed to be like law of the land across. And so you have, she might have in front of her, let's say if she's circuit court, then there is a Michigan Supreme Court or Michigan Court of Appeals decision that has said, oh, well, with this unique aspect or this part of the Second Amendment, this part dealing with firearms, there's a law in the books that it's allowed. This law is allowed to be on the books regulating this part of gun usage or whatever. Okay, and so, but maybe in other jurisdictions, there's cases pointing out, no, that's nonsense. You can't do that. And maybe, there's lots of other jurisdictions that are saying that. I could see how a circuit court judge would say, listen, I'm bound by the decision that's over me. I don't agree with it, but I'm bound by it. And I can't just go outside of the scope of that. The interesting thing is, if I were in the shoes of that judge, and if that were the case, where it's, it's clear that it's unconstitutional, but the court above me that I'm bound to follow has made a clear ruling that I have to follow this unconstitutional law, that this unconstitutional law is supposedly good in the eyes of that jurisdiction, I would go ahead and say it's unconstitutional. I recognize this case, and then I would differentiate it any way I possibly could, or I would, whatever I needed to get to the result of having the constitutionally protected rights of that individual protected. I would do what I had to do. But I could see how it wouldn't even be 5 minutes before the prosecuting attorney would have their appeal put together. It would go up to that very court that has said, nope, this law is good, and you have to have, convictions for that violation stand. How a prosecuting attorney could just bring it up back to that court and say, look at what this judge did. This judge went rogue. And then you'd end up, they'd kick it back down, and then, remanding it to have an opinion consistent with the whatever. You know what I mean? Like, I get that a lot of judges are afraid of, what's strange is they're not afraid of violating your rights. They're not afraid of being overturned when it comes to matters of violating your rights. Violating your rights, I'm willing to risk being overturned. I'm going to violate your rights here, now, and every which way until Sunday. But when it comes to standing up for your rights and defending the principles of the Constitution and how that might be in defiance of a higher court, how they might be risking being overturned or overruled because they stood up for the Constitution, judges they don't do that. They're not willing to risk being overruled by a later court or a higher court when it comes to, or on the basis of defending the Constitution. So it's really absurd. But it is what it is. It's just, I'm just describing, unfortunately, the facts that are before us, not what I would like to see happening. But at any rate, so I just, I think it's important that we, because I think you had emailed me that decision recently, didn't you?
Yes, I did, ma'am. I did email that to you, and I emailed you that one was out of the Ninth Circuit because they just recently had some individuals that were convicted in the Ninth Circuit, and now they just filed. And another gun tuber just recently covered this, that their case is now going to be heard, that the individuals had their rights violated, and that was a pre-Bruin decision, but they're going to be able to use the Bruin decision to say, hey, these convictions need to be vacated because now they've gone to federal court and said that civil rights were violated. Even though they had gotten convictions in the lower courts, now they've gone to federal court and filed for civil rights violations because they feel that their Second Amendment rights were violated because the judges did not follow the Bruin decision, even though it was pre-Bruin. They should have done the same kind of research as the Supreme Court did before rendering their verdicts.
And I hope they get all that. Just, I guess in my read of how, I remember seeing the emails that came from you, and then I opened it and I'm like, oh, this is not even a jurisdiction that's relevant to what you're doing. So I thought it was more just informative. And so I didn't really pay too much attention to it for that reason. So I'm glad that you bring that up and that's why you were sending that to me, because, I just, and I'm not saying you shouldn't pay attention to what other jurisdictions are doing. Sometimes that's all you have. And you take what you got and you work with it and you do your best to try to convince the court to do what's right. But just keep in mind the biggest thing is that you're not going to get any traction on that full faith and credit argument because another court in a different jurisdiction has said something, or just because another state has made a law about something, and it doesn't mean that every state has to integrate that and make that their own case precedent or their own statute. It just means they have to recognize something that has come to fruition or finalized. What is the legal result of that case or that statute in another state, basically? So, anyway.
And just to wrap this up real quick, I'll tell you that the case that they were using here in the state of Michigan, because it might be beneficial for anybody else that's going through it in the state of Michigan, and I typed it in the chat. It's the people of the state of Michigan versus Kimberly Aaron Langston, and it was in 2024. She took it all the way up to the Supreme Court with her attorney, and luckily she was able to afford an attorney. I'm actually use a court-appointed public defender, and like I said, trying to get this guy to do anything is like pulling teeth. He's not really for the Second Amendment, and he doesn't know anything about Second Amendment law. I had to basically spoon feed everything to him. So.
Well, again,
So I'll leave it at that.
it's not just public defenders. There's a lot of attorneys that claim to be out there, even in the fight for freedom, that claim to be experts in constitutional matters and whatnot, and then they still don't advocate the right way. So that's why when people ask me all the time, in the last week alone, I've had another dozen people asking me for referrals for attorneys. If I can't help them, then give me a referral for an attorney that can handle this type of constitutional situation or this type of case. And I'm like, you know what? I don't have a referral, because of all the ones that I have come across, none of them do I feel comfortable saying that they are. I know for a fact that no matter your constitutional issue, that this attorney is going to handle it appropriately and really stick to the terms of the Constitution and defend it zealously. It's sad. And some of these people are friends. Some of these people I've known for many years. I mean, there's a lot of attorneys I've known for many years. I've been an attorney for a long time. So I know a lot of other attorneys, but yet some of them, even though their heart might be in the right place, they are missing the mark. And so it's frustrating, but anyway. So I appreciate you calling and kind of fleshing those issues out, though, and kind of giving me clarity on what those cases were sent to me for. But yeah, keep watching. I mean, keep trying to use those cases to see if you can do something with it, but just know how to use it. And if you're using persuasive authority from another jurisdiction, just make sure to recognize that and then craft your argument to acknowledge. Oh, look, I'm going to remember for the last 10 seconds of our call to switch the screen to say caller on live. Anyway, just remember to craft your argument to let the court know, hey, I know this is from another jurisdiction, but this is what we should be doing here, and this is why. And in your case, if you want to tie it specifically into, the Bruin case, unfortunately, the other case that you mentioned came after the Bruin case, if I remember correctly. So they essentially said, well, yeah, Bruin says this, but we're still saying that even in light of Bruin, the law of the land is still okay here in Michigan to do this. That's where you have a struggle. But at any rate, it's too bad that individual, that defendant didn't take it up to the U.S. Supreme Court. It would have been interesting to see.
I think finances is a big problem too. I mean, a lot of us little serfs, peasant, peons, blue collar workers, we just don't have the funds. I mean, it's just really expensive process to go through the entire process. And then look what they're doing to you. They have you going through all this here for your case. I mean, would a lay person be able to do all that on their own? It would be very, very difficult, I would believe.
No, you're right. I don't think a lay person would be able to really figure it out. I'm having to figure it out. I'm overwhelmed. Just this morning, I had already pulled up all the different kinds of, there's a frequently asked questions section. There's the actual court rules, which is, 86 pages. There's, all these different things, and I'm printing it all out so I can make my highlights and I can flip back and forth. Because even reading the rules, it's like, well, this one references this one, which references this one. You got to go back to this one, and then does this really apply? And I'm not sure. And it can be extremely overwhelming. And I've been in the legal field for over 20 years. So, and I've worked on Supreme Court cases before, U.S. Supreme Court cases, certainly, but even Supreme Court cases in other jurisdictions, and it's overwhelming. So, yeah, I hope that there can be good that will come out of it. And I do this show in hopes that I can encourage people to not give up and keep going on their own. And, if I got to help you, like today, hopefully I helped you kind of get that different lens to still look at some of those cases that you're looking at, but just change the lens through which you're looking at them, because of that issue with the full faith and credit clause. But don't try to apply common sense too much in reading any of these cases, because common sense and the law never mix.
Yeah, I'm noticing that the common sense doesn't seem to apply in the injustice system going through this whole process now for the last 2 years.
Yeah, unfortunately.
I do think the next step is what they're doing through the prosecutor's office because he's saying this is a law now, and we found out it's not a law, it's just a policy through the prosecutor's office. Anybody involved in a gun case has to do the mental health illness evaluation. And even if you reject it and you lose at court, you're still going to have to do the mental health illness evaluation when they incarcerate you. So this is another step they're trying to do to disarm people in the state of Michigan.
And yeah, and basically it goes in hand with all the red flag laws that they're doing there. And, you know, the irony is that the people that have the majority of the dangerous mental health conditions where they have an interest in harming others, the majority of them are liberals with liberal policies. The same people who oppose guns, who oppose, you know, any kind of freedom of that regard, those are the same people that, statistically speaking, have more of the dangerous mental health conditions. I mean, everybody these days has some sort of mental health condition, whether it's anxiety from how the government's going or depression or whatever. But I mean, the people who, you know, by and large are okay with harm coming to other people simply for their viewpoints, for example. That is a liberal's perspective, not the conservative's perspective. And so by and large, is it the liberals buying the guns or you know, or is it conservatives? Well, it's conservatives that are the majority of gun owners, but it's the liberals who have these, you know, extreme notions of causing physical harm to people that they disagree with politically. Those are the ones that are purchasing the firearms to cause great bodily harm. Those are the ones that need to be taking those mental health assessments that you're mentioning. But of course, what are the Democrats trying to do? They're trying to apply these mental health assessments proactively, unconstitutionally, to the whole class of traditional gun owners. That there's no indication whatsoever that mental health is at issue or that someone's mental health is putting others at risk. And if you really want to hurt someone, and you have a mental health issue, you know, some sort of schizophrenia or, you know, other paranoid delusions or something that is, you have a mental health issue that is posing a physical risk for life or safety to other humans, whether you get a gun or not, you're going to be at risk. I mean, if you're a risk, if you're a safety risk, you're a safety risk whether you have a kitchen knife or you have, you know, a little a lighter in your hand and a little can of gasoline, or whether you have a big pile of bricks or rocks near you, or whether you have a firearm at your disposal. If you're out to hurt someone, you're going to hurt them no matter what methodology is in front of you.
Yeah, I did bring that up to my court-appointed public attorney because his excuse is, well, they're going to use the excuse, well, they just want to make sure you're not going to go to a school and shoot up a place. Now, you know, that's really dumb, but okay, fine, let's go with your narrative. I deliberately, and I do live next to, within the area of a school, and I deliberately, when I drive, go the opposite direction away from the school. Why? Because I'm cognizant and mentally competent to know that you cannot go within 1,000 feet of the school property, and that includes a sidewalk that's adjacent to the school. So I would deliberately go in the opposite direction from my home so I wouldn't violate the federal law. Now, that doesn't sound like somebody who's mentally ill. It sounds like somebody who's cognizant of what the federal law is and is obeying it. But if I wanted to violate the law, I would go ahead and not even take my firearm with me. If I wanted to do harm in the school, what would prevent me from driving into the bus lane when the kids are lining up to go home from school or going to school? I mean, you can use your vehicle for that.
Exactly.
So that doesn't make any sense.
Right, exactly. And that's the thing. People, I mean, we've seen it just in the last 12 months alone. There's been multiple incidents where you have people that are using vehicles as weapons that are murdering people by plowing through in crowds and at parades and other scenarios, get-togethers of whatever kind. You have people using vehicles as weapons. So if you have people using vehicles as weapons and you have people using guns as weapons, and so they're saying, well, we'll have to give you a mental health evaluation if you just want to own a gun. Okay, well, are you giving mental health evaluations to people who want to own cars?
Uh-huh.
Are you giving mental health evaluations to people who want to buy pavers or bricks from a Home Depot? I mean, anything can be used as a weapon. So, I mean, certainly they do not give mental health evaluations to everyone buying gasoline and lighters. So,
Well, I just heard we're headed down the road as far as cutlery control is concerned, because one of the most famous chefs out there, Gordon Ramsay, now when he buys new cutlery for any of his restaurants, he has to get a permitting process through the United Kingdom. That's headed our way here in America if we're not careful.
wow, there's a lot more crazy that's happening over there in the
Yep.
UK than just that, unfortunately.
Yep.
But yeah, some of those bad things are coming our way if we don't wake up and stop it. So, well, I appreciate your call today, and I do wish you luck on still trying to fight the fight and get somewhere, get some traction in your case. So.
Next hearing date's September the 4th at 11 o'clock. We're doing the evidentiary hearing, and then we're going to go from there, I guess.
All right, everybody, you heard him. Please pray for him and his situation and his case for September 4th and that evidentiary hearing and any motions or things that might be brought up in between now and then as well. So, all right, thank you for calling in. Have
Thank
a great
you,
day.
You too, ma'am. Bye-bye.
Bye. Okay, so let me just make sure that, let's see. I want to make sure there was not a question that I skipped over. There's a lot of great conversation as usual in the chat. And, when we have Liberty Warrior in the chat, there's often a lot more conversation just because he's always got something to say about the Constitution or the laws or proper role of government. So anyway, if I missed something that somebody asked, I apologize, but I've done my scrolling up and down multiple times and I am not seeing any more that say question with a question that I have not read out loud and tried to address in some way. So with that being said, I've spent more time than I wanted to today. I was actually going to keep the show short, but it is what it is. I guess it's short for the days as compared to the days that we go 2 full hours. Today was only an hour and a half. But I ask you to keep me in your thoughts and prayers. We've had several very challenging situations dealing with, from student loan issues, things, not new student loans, heaven forbid, things that are happening to my student loans that are not within my control. And, thank you, government, changing the contract on me after I took out the loans, 20 years after I took out the loans. Not fun times. I wouldn't have taken out the loans if they were going to change the terms afterwards. Anyway, and health insurance issues with our health insurance changing, and everything is topsy-turvy, and it's just, we've got a lot of things going on and changing for us, and a lot of stress. And then, of course, the biggest thing of all probably is this case with the city and how it's been dragging on now, 3 years? I think it was Labor Day 3 years ago is when I got the first call from them about this. And, we've been doing everything we can. And for those of you who are new, who are maybe catching the show for the first time, take a look at some of the other episodes that we've had, listen to those. I kind of describe it in more detail, but to put it point blank, we are in a damned if we do, damned if we don't situation, because the only thing we've been, the only finding the magistrate ever made is that we were guilty of not having obtained a permit for 3 things on our property. And the thing is, the city says they won't give us the permit for those 3 things. They have varying reasons that are all not supported in law. But they say they won't give us a permit. And here's the thing. So we can't get the permit. So the city's saying, nope, you just got to remove the stuff. If we if we do remove the stuff though, for different reasons for each of the three things, there's multiple reasons that the city would then be able to come and start fining us for having removed the things. For example, our parking pavers. If we don't have those pavers, then we can't legally park our vehicles on our own property, and we can't park them on the street. And there's no, like parking anywhere. Like, this is it. We have to be able to park on our own property. So they literally are stopping us from having vehicles if we have to tear up these pavers. And there are cases here in Florida, in fact, one that is making its way up to the Supreme Court as we speak, where the homeowner was being fined every single day, and I think the total fines are like $150,000 or something like that, and they're trying to take her home too. And where her violation was that they had a driveway, but the driveway wasn't wide enough to hold two vehicles, and so they were partially on the grass on both sides. And like one tire was on the side on the grass, and a front and a back tire on one side of the car, I should say, was on the grass. And so the city was fining them every single day. They were getting fined because they didn't have it. They were parking on the grass, because most municipalities down here have an ordinance that says you can't park on your grass. You can't park on mulch. You can't park on stone. You have to park on asphalt, brick, or concrete. And, we didn't go all crazy and pour more concrete and asphalt to expand the driveways to make them the legal size according to the city. We put in pavers, and we put them in according to the specifications the city code says. But anyway, so if we take out, this is the damned if we do, damned if we don't. If we do what they say and remove the three things they have told us to remove, then they can fine us and continually fine us for having taken them out. And we're damned if we don't, because if we don't, then we'll continue to be charged $75 a day for keeping them here. And that doesn't end. And the city thinks they're going to be able to just come and take our house, put a lien on our house, and take our property, take our cars, take our stuff, literally clean us out. And that the fines will keep growing, and that they'll be able to go and keep getting new orders for fines. And that it will never end, which is not what the law says. But it's not even what the statute says. It's not even what the code says. But that's what they think they could do, and that's what so far the courts have allowed them to do. So we're damned if we do, damned if we don't. We can't take the stuff out. We can't leave it in. It's required to be there. But they wouldn't give us a permit to put it there. So they're trying to make us, it's like a big mess. Anyway, so please pray for me as I try to navigate the even more complex layer of judiciary that is known as the United States Supreme Court. And all the procedures, rules, and everything, from the kind of paper and the different font. You can't even do Times New Roman. You can't use Arial. Those are the two most common fonts accepted and required by most jurisdictions across the U.S. these days. Nope, it's got to be a totally different. It's in the century font family that you have to have them for the U.S. Supreme Court. And size 12 only, with 2 point something, some other made-up word that I have never even heard of, to go after your each line and all that in ways that just make no sense. It's not saying double spaced. It's saying 2 point something. At any rate, so keep us in your thoughts and prayers on that, please. It's 1,000,000,000 to 1 that they're going to take the case, let alone that they're going to, rule in our favor. Although, quite frankly, if they take the case, they're going to have to rule in our favor because the law is on our side. And I'm limited to 40 pages to convince them in 40 pages why we win. I don't know how I'm going to possibly do it, because it is, I just explained it to you guys in layman's terms, but in order to explain exactly how all the laws are requiring all the stuff to be here and all the excuses that gave for reasons why they're denying are, giving us permits, and how those are not in the code of ordinances and all that stuff. Like it's so complex, and it's not my doing. It's all the ways that they're violating the law. So I gotta try to squeeze it in all I could do. Anyway, so yeah. So anyway, I think that I don't see any other questions that came through. So I appreciate you guys for joining me today. And it looks like our next day together is going to be Tuesday, August 26th. Let me just double check to make sure I don't have something. That date just rings a bell for me. I am actually going to be moderating a candidate forum in Volusia County the next day, August 27th in the evening. So it's going to be interesting. We're going to have some county council candidates there. We're going to have some congressional candidates there. And I myself drafted the questions that I will be asking them that day. So make sure to stay tuned for that. And anyway, I'm going to go ahead and go to that date on the calendar just to make sure. Yep. I plan to be here with you guys at 12 p.m. August 26th. And we'll be taking all of your constitutional and legal questions at that point. In the meantime, please make sure to hit the like button, give it that thumbs up, share it far and wide, share the YouTube link on Facebook, share it on your Twitter account, and if you have a Truth Social or whatever, all the different places, share it, and tell people about the resources that we have for them. And if you can make a recurring donation, that would be great. If you can make a one-time donation, any little bit helps, even if it's only $5. If you can donate $5, that will go towards helping. Could you imagine if I can get 100 people to donate $5, that'd be $500, and that would help cover one portion of expenses for all the stuff that I have that goes into doing all this for you. I haven't gotten paid a dime. I don't get a paycheck. The government thinks I don't work. Social Security is never going to give me anything even though I paid in all the years before, but it's never going to account to enough hours because they think I'm not working. Okay, so I'm not getting a paycheck. This isn't helping me personally. This is just trying to pay for those out-of-pocket expenses to keep doing this. So anyway, if you can donate in any way, shape, or form, go to restorefreedomkh.com/donate, and you'll see all the possibilities for ways to do that. I make it as easy as possible for you there. My preference is Venmo or Cash App, simply because there are no fees there. But anyway works. restorefreedomkh.com/OB case. That's where you could see the latest and greatest of the entire case. I didn't put literally every single document. I put all the major ones there and anything that might be helpful, procedural in nature to you if you're going through your own similar case. But take a look. It's in chronological order by court. So first came the magistrate court, and all the stuff in the magistrate court is there. And then I went to circuit court, and even though there was some magistrate stuff filed afterwards, I then separated out the circuit court stuff. And then I have Court of Appeal stuff. And so even though there's some stuff filed in the circuit court and the magistrate court while Court of Appeals was pending, all the Court of Appeal stuff is together. And I put dates by all of it so you can see it. And I indicated in each section, like, hey, at this point, we now had a Court of Appeals case going, or this point, we now had a circuit court case going. So I made it as easy to understand as humanly possible. But go ahead and check out all that stuff so you can see how to put together your own cases. How do you put an appendix together? How do you put exhibits together? How do you use bookmarks? How do you describe things? How do you highlight? What do you do to put a case together? I want you guys to know that, because you can't always trust an attorney to do it for you. Maybe you can't afford an attorney. Maybe they need help. You show them my resources and have them start there. And if you just look for any other resources that we have, other cases and other things, like my briefs that I don't even remember if my briefs that I filed in the cases against the governor with her executive orders in 2020, I don't remember if those I ever made it to my website yet. I know I've been meaning to do that. But anyway, cases like that, cases like my Allegan case, the election trespassing case. That's if you go to restorefreedomkh.com/resources, all the rest of the resources will be on that tab. So anyway, and keep in mind, it's just me. It's little old me. I'm the only one running the whole website these days and have been for the last few years. So that's why not a whole lot changes from day to day. If I'm working on legal briefs, I can't also be doing the website. But anyway, so keep that in mind. And I appreciate all of you. And yes, checks. Somebody said something about sending a check. If you have a check to send a donation, that works wonderfully too. That has no fees either. Just a lot of people like to do electronic or quick methods. Some people don't even use checkbooks anymore. And that's understandable. So if you're looking for an electronic method, something that's quick, something traceable in that regard, that's where I would say Venmo and Cash App are preferred because they have no fees, but I can still do any kind of credit cards through PayPal or whatever. And of course, if you send checks or money orders or any of that stuff, I can still accept that as well. So I appreciate anything that you can donate. I've had people send me a few bucks in the mail, like literally sending me a $5 or $10 bill in cash, and that's fine too. Obviously, I don't really trust USPS, so it might not make it here, but I have had people do that in the past, and I appreciate any and all of it that you are able to assist with. I know times are tough for everybody. All right, with that being said, I'm going to go ahead and sign out for now, and wish that you guys have a wonderful next couple of weeks, and I'll see you on August 26th at noon Eastern Standard Time.
Our work to restore freedom would not be possible without support from people just like you. From the various software and hardware needed to the legal research materials, every dollar you can donate helps. Make sure to like and share this video too. And remember to follow and subscribe and click that notification button. Together, we can restore freedom.